Out there, legal warriors, did you know that your chances of winning a criminal case is sort of like an elevator? There's things that make that elevator go up and improve your chances, and things that make that elevator go down to places we don't want to be. So if you're interested in those factors, if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. What do you mean by an elevator, Lance? Well, on this hypothetical and this metaphor, when we want to go to the penthouse, right? We want to go to the top floor in our criminal case. We want to get that dismissal or some type of action that might lead to a dismissal of the charges. We don't want to go to the basement. Don't go to the basement, which is jail or prison or a conviction or getting fired. And so what factors makes it more likely for the elevator to go up to the penthouse where we've got freedom and avoid going down to the basement where we lose our freedom or lose even more things than just our freedom, maybe our entire family? So I think there's about 4 different things we need to consider. And first of all, it may not be so obvious. The first most important thing, believe it or not, is where the crime happened. The jurisdiction that is prosecuting the crime has a lot to do with the chances of the elevator going to the penthouse or the elevator going down to the basement. And why is that? Well, let's just back up and have a little bit of lesson about how criminal courts work. So most of the time, if someone's accused of a crime, it's not a felony. It's going to be a gross misdemeanor. In cases like domestic violence, assault 4th degree, DUI, theft 3rd degree, criminal trespass, all those things are the most common crimes we see, and those are gross misdemeanors. Now, where that crime takes place geographically controls what court gets to hear the crime, and more importantly, what prosecuting agency gets to prosecute the crime and decide what button they're going to press. Are they pressing a button to the penthouse, or are they pressing a button to the basement? And for the most part, think about it this way. If you have a crime that happens within the city limits of a city, in almost all cases, crimes that happen within the city limits of a city are going to be prosecuted by a city prosecutor. And as a general rule of thumb, city prosecutors have a little bit of different outlook than state prosecutors because, everything is personal. City prosecutors may take a more therapeutic approach to handling cases where they're trying to figure out a way to make the most out of the alleged crime, while state prosecutors in some cases might just be trying to make a name for themselves and move up through the ranks so they can get promoted to prosecute felonies, make more money, have better benefits, stuff like that. City prosecutors can't get promoted because they're not working for a county government. Only county governments can prosecute felonies. So if something happens in an unincorporated area of a county, then that's going to go to the county prosecutor. And we're just talking as a rule of thumb, they're going to be more harsh on resolutions because they have supervisors looking over their shoulder, and there's a way that they may have an incentive to try to rack up convictions and do a good job in the eyes of their supervisors so they could move up to more serious cases. Now, your mileage may vary. I can name a few cities that are pretty hard to deal with. I won't name them here to protect the innocent. But for the most part, if you've got a city case, that's going to be one way that it's more likely there's going to be more outcomes available that put you in the penthouse versus the basement. As far as a second factor that we'd want to go to next is, what is it that you do to help your case after you're accused of a crime? Now notice I'm not talking about whether you're guilty or innocent to begin with right away, because guilt or innocence is mainly figured out at a trial, and we'd like to avoid trial and go to the penthouse without having to risk the jury, if we can do that. But basically what we're worried about here is what you do after the fact, what type of affirmative things maybe that you do that can help the prosecutor be more willing to push that button to the penthouse. So what do you mean? Well, think about it this way. You're accused of some type of assault charge, and the prosecutor has 100 cases on their desk. And the prosecutor needs to get rid of some cases, right? They can't try all 100 of these cases. So maybe your attorney says, hey, I'm going to have you do an anger management class, or I'm going to have you do DVMRT classes. And what are the objections to that? Well, isn't that admitting guilt if I do that? No, it's not admitting guilt. It's not admissible in evidence against you. Well, won't the court look at me bad if I do these things? And does it say I have a problem? No. Remember, we're using a tool here to try to get the prosecutor to hit that penthouse button, right, and let us go. So we'll have you do something, and then we have proof for a prosecutor. And if you're a prosecutor, let's say you're out there watching, you're the prosecutor, and you've got 100 cases, and you've got 10 assaults, and you can only prosecute one of these to trial this month. You don't have that many trial dates. You look at all of them, hey, one of these people have done some stuff to educate themselves. They've done some stuff to, address possible anger. Well, as a prosecutor, do you feel better or worse about giving that person a better outcome? Are they a better risk because they were willing to educate themselves? A better risk that they're not going to reoffend? Or are they a worse risk? Well, of course, it's a better risk for the prosecutor to let that person go or give them a better outcome if they've done some stuff to educate themselves. So what we say in my office, once the case is old enough and the client has done enough, then we're more able to have the prosecutor hear our version of what happened. Because if we do nothing, the prosecutor's ego, it's not their job just to let us go, right? It's their job to do justice. But unless you have a very exceptional case where you can absolutely prove innocence, they're listening to their police, right? The police started the charge, not the prosecutor in non-felony type cases. Therefore, if they just start dismissing everything that the police do, are they going to be a prosecutor very long? Probably not. So talk to your attorney about, are there some affirmatives that you can do to make it more likely you're going to go up as opposed to going down? Now, if I move on to factor 3, we do at this point want to look at the quality of the evidence and how sensational the evidence or the injuries are. The more sensational the evidence or the injuries are in a case, the more likely that prosecutor is going to pay attention to it and more likely hit that down button, right? If you've got a traffic case where you just pulled over for a DUI and you cooperate and everything's cool, no big deal. If you have a traffic case where you drive 110 miles an hour and you flip your car and you have 2 passengers and 3 poodles are killed in the car also, that's going to get attention. They're going to remember that case, the prosecutor. They're much more likely to press the down button and say, hey, this case is so heinous, I'm going to use my limited executive function to make sure that person pays, as opposed to the one that I'm not going to pay as much attention to because it's everyday run-of-the-mill. Also, we have to worry about, does the case have injuries, right? Were there weapons used, those type of things? And does the case stand out for that level of court, right? There's certain types of cases that non-felony courts could hear, and some cases are more, just by the very definition, shocking than others, right? Assault 4 with SM is a lot different than assault 4, and you can look up what that is. But for non-felony cases in a municipal court, assault 4 with SM is one they're always going to pay hard attention to, and therefore it's going to be more likely that they press the down. Now, does that mean that we still can't go up and be free? No, because all of the same factors apply. But just realize that we're talking about what are the factors that can lead to go up to freedom or down to a more negative outcome. And I think the fourth and final factor that we take a look at in these cases is what is the motivation of the people complaining against us, right? If it's the police, right, then the police are probably going to pretty consistently show, and the prosecutors can sort of rely on them to show up to testify, and that's more neutral, okay, unless we can find some good Brady material against the officer and show the officer's not reliable. But what about an alleged victim where there's a victim in the case, right? For a store, a store on a theft case, they're not going to show up and raise Cain about the stuff, and so that's going to be more likely we press the up button towards more likely to get a dismissal in the long run. But if you've got a ex-partner, someone that's in a messy divorce with you, someone that's really against you, and they're going to keep ringing the prosecutor's phone and say, I want this person such and such to be in jail, it's more likely it's going to be harder for that prosecutor to press that up button to go towards the penthouse. It's more likely they're going to be wanting to press that down button to go towards the basement. So we have to think about these things, and that's one reason why time helps cases. In cases where there are alleged victims that are humans and not stores and things like that, as time passes, time heals all wounds. Well, it may not heal it altogether, but as time passes, passions go down, anger oftentimes goes down, other things can attract the supposed victim's attention, and therefore we don't want to rush, right? Rule 1 for our office when we say, hey, are we willing to help you? Rule 1 is patience. The client has to be patient because time typically helps cases if the client can obey Rule 3, which is stay out of trouble, right? Time helps if you can stay out of trouble in most cases. And there's exceptions to that, but these are the general factors, the 4 that I can come up with off the top of my head that or make it more likely to get a result we want up there versus a result we don't want down there. So I hope if you found that useful, you'll like and subscribe. And more importantly, if you have a criminal matter in Washington State, feel free to give my office a call. If you get on board, we'll listen to what happened. We'll identify a way forward. We'll be there for you. And hopefully hit that up button. Bye-bye.